Your Honor, I'm here to get custody of my grandchild and also to make my or soon-to-be ex-son-in-law to pay the child support. My daughter was diagnosed with lymphoma, and Your Honor, it was a long and difficult process, as you can imagine, and he wasn't up for it, and he left. And so I went and helped my daughter and helped my granddaughter.
Welcome back to Court Code, where real courtroom drama unfolds with clarity and context. If you haven't already, make sure to hit that subscribe button and turn on notifications so you never miss a deep dive into cases that reveal the heart and heat of family court. Today, we're reviewing a powerful and emotional episode from Support Court with Judge Vonda B., the case of Berkeley versus Allers. This case goes beyond a legal disagreement. It's a painful reflection of love, loss, and the complex boundaries between family and the law. The case opens with Ms. Berkeley, a grieving grandmother, stepping before the court. Her daughter had passed away after a long battle with lymphoma, and now she was seeking custody of her granddaughter.
Through this process. And they had been legally separated. He was paying child support, but when my daughter did pass away, I checked into the account. I had access to her financial business, and I checked the account, and he was not putting the payment in there. So I am looking for the back payments that are due, and I am looking to get custody of my granddaughter.
Okay, so let me just make sure I'm clear. Your daughter is deceased now.
Yes, ma'am.
And my condolences.
She also wanted the court to enforce child support payments from Mr. Allers, her daughter's estranged husband and the child's father. According to Ms. Berkeley, the couple had been legally separated, and Mr. Allers had been paying child support. But when her daughter passed, the payments stopped. Having had access to her daughter's financial affairs, she discovered that the support money was no longer coming in. With her granddaughter's future in mind, Ms. Berkeley stepped into court asking to resume those payments and to gain custody of the child. Judge Vonda immediately clarified the situation. First, she offered condolences, then cut right to the legal facts.
Just trying to step into the shoes of your daughter.
Yes, ma'am.
Okay, I understand.
I think it would be far more appropriate for me to be raising the daughter than for him.
Okay, why do you believe it would be more appropriate?
He has a lifestyle that I don't necessarily think is best for raising children.
Okay, well, I guess I'll get that from him. Mr. Alberts?
Yes, Your Honor.
What's going on?
Some of those details are correct.
Which ones are not correct?
The fact that
The grandmother, though clearly well-intentioned, was trying to step into the shoes of her deceased daughter. But as Judge Vonda pointed out, that's not how custody and child support work under the law. When a custodial parent passes away, the obligation to pay child support ends because there's no longer a recipient. In this case, the only surviving legal parent was Mr. Allers, the child's father. That meant the child now lived with him, and therefore there was no legal basis for him to continue making child support payments to anyone else. Ms. Berkeley tried to argue that she had been more present and that Mr. Allers had abandoned the family during a time of crisis. She claimed he spent too much time at bars and relied heavily on babysitters.
What lifestyle is she talking about?
I don't know. Ask her, Your Honor. I really don't know.
What lifestyle?
Well, he spends a lot of times in bars.
Okay.
A lot of time in bars. He spends a lot of money on babysitting because he spends a lot of time in bars.
Okay. Going to the bar is legal.
True, but who's going to be there to help with homework? Who's going to be there to hear the sad story of how she was bullied in class?
She suggested an unstable environment for a child, but when questioned further, her claims were based on nightly phone calls, where the babysitter, not Mr. Allers, would answer. She admitted she didn't truly know if he was present or not. Judge Vonda reminded her that unless she had proof he was being neglectful or endangering the child, there was no legal ground to grant her custody or resume child support. As difficult as it was to hear, Judge Vonda made it clear, legal decisions must be based on facts, not emotions. The court does not grant custody or child support rights to someone just because they've been involved or feel they're better suited. The law prioritizes biological parents unless there's compelling evidence of harm or neglect.
Because I call every night to say goodnight to my granddaughter,
Okay.
and it's the babysitter that picks up the phone.
Okay, so you don't necessarily know whether he's there or not, right? You don't necessarily know if he's present or not. You just know that the babysitter picks up, right?
Yes.
Okay.
Technically, yes.
Okay, well then technically you don't really know what he's doing unless you are actually at the bar with him. Or you have someone spying on him, which is completely wrong. But that really has nothing to do with why we're here.
Since the child had been living with Mr. Allers for a full year following her mother's death, and there was no legal issue regarding his care, the court could not override his parental rights. Even when Ms. Berkeley raised the possibility of the child wanting to live with her, Judge Vonda firmly stated that a 6-year-old does not have the legal right to make that decision. Unless Mr. Allers proved to be unfit, the court would not interfere. However, Judge Vonda did ensure that Mr. Allers would continue to provide medical support for the child through his employer, as required. But as for additional child support or custody changes, the court denied the request. This case is a sobering reminder of how the law functions when it comes to custody and financial responsibility after the death of a parent. While Ms. Berkeley's intentions were rooted in love and a sense of duty, emotions alone cannot replace legal standing. Judge Vonda B. ruled in line with Texas law, emphasizing that without evidence of harm or neglect, the child remains in the custody of her father.
The only thing I can order, pretty much is that he maintains that child support, the medical support on the child, but other than that, and that's through your employer,
Yes.
that's all that he can be ordered to do. I'm not going to make him pay child support for a child that belongs to him and that lives in his house.
Fine.
Okay. Is there anything further from you?
No, Your Honor.
Anything else from you?
What if the child wants to come live with me?
Well, she's 6 and you're not her parent. So she does not get to make that call.
And no further child support is required. At Court Code, we don't just watch courtroom cases, we break them down, analyze the laws at play, and explore the human stories behind each argument. If you know someone who's faced a similar situation, or if this case resonates with you, drop a comment below and share your thoughts. Your story might even help someone else going through the same experience. Don't forget to subscribe to Judge Bench for more courtroom insights, emotional legal, battles, and real-life justice. These kids aren't raised on air alone. This is Support Court.